I knew something was wrong the moment I saw the bright orange envelope sticking out of my mailbox like a warning flag on a windy day. After 15 years as a general contractor in Minneapolis, Minnesota, I had developed an instinct for trouble, and this envelope screamed it. My name is Harrison Drake, and I had moved into the Riverside Meadows community just 8 months earlier. The house was perfect, a beautiful 2-story colonial with a spacious backyard that backed onto a small wooded area. My wife had passed away 3 years before, and I needed a fresh start somewhere that did not remind me of her everywhere I looked. The HOA seemed reasonable enough when I signed the papers. The president, a middle-aged woman named Brenda Patterson, had smiled warmly and assured me the community was friendly and low maintenance. I should have known better. I grabbed the envelope and walked up my driveway, noting the late March slush that still clung to everything despite the slowly warming temperatures. Minnesota winters were brutal, and this one had been particularly harsh. We had gotten nearly 70 inches of snow, and the plows had worked overtime keeping the streets clear. Inside my kitchen, I tossed my keys onto the counter and opened the envelope. The letter was printed on official HOA letterhead, and the words made my blood pressure spike immediately. Dear Mr. Drake, it has come to our attention that your property fence has sustained significant damage and presents an unsightly appearance that violates Section 7.3 of the Riverside Meadows HOA covenant. You are hereby fined $2,000 and given 30 days to repair or replace the damaged sections. Failure to comply will result in additional fines of $100 per day. I read it twice, then 3 times. $2,000. I walked to my back window and stared at the fence. Sure enough, a 10-foot section along the western edge was completely demolished. The boards were snapped and splintered, pushed inward at odd angles. But here was the thing, I had not touched that fence. The damage had not been there before the last major snowstorm 2 weeks ago. I grabbed my coat and went outside for a closer look. The snow had mostly melted, but I could still see the evidence clear as day. There were deep gouges in my yard where something heavy had pushed through, and chunks of hardened snow and ice were still wedged between the broken boards. This was not normal wear and tear. Something had hit my fence hard, and I had a pretty good idea what. The community had a contract with Northern Snow Services for winter maintenance. I had watched their massive plows tear through the streets all winter long, pushing mountains of snow onto the edges of properties. My fence sat right at the end of a cul-de-sac where the plows turned around, and I had seen them get uncomfortably close to my property line more than once. I pulled out my phone and took about 50 photos from every angle, documenting the damage, the plow marks in my yard, and the way the boards were pushed inward rather than pulled or fallen outward. This was impact damage from something large and mechanical, not weather damage. The next morning, I drove to the HOA office, a small building near the community center. Brenda Patterson sat behind a desk that looked like it belonged to a CEO rather than a volunteer position. She was in her late 40s, with severely styled blonde hair and the kind of pursed lips that suggested she had been born disapproving of things. Mr. Drake, she said without looking up from her computer. I assume you received our notice. I did, and I need to talk to you about it. That damage was not caused by me or by weather. Your plow service hit my fence. Now she looked up, and her expression was one of practiced patience dealing with an unreasonable child. Mr. Drake, we have had a very harsh winter. Many fences in the community have sustained weather-related damage. Your responsibility as a homeowner is to maintain your property regardless of the cause. This was not weather damage, I said, keeping my voice level. This was impact damage from a plow. I have photos showing the plow marks and the direction of the damage. Your contractor destroyed my fence, and the HOA should be covering the repairs. Brenda folded her hands on her desk. Mr. Drake, I understand you are new to community living, but this is not how things work. The HOA is not responsible for individual property maintenance. You signed a covenant agreeing to maintain your property to community standards. The fine stands. Then I want to see the plow service records for the last storm. If they did not come down my street, I will pay for the repairs myself. But if they did and they hit my fence, then someone owes me compensation. Her smile became even more condescending. Mr. Drake, those records are HOA property and not available for public review. Now, if you will excuse me, I have other matters to attend to. Your 30-day notice period started when you received the letter. I suggest you begin making arrangements for the repairs. I left the office furious but not defeated. I had dealt with bureaucratic nonsense for years in the construction business, and I knew there were ways around these roadblocks. The HOA might own the plow records, but those records had to come from somewhere. Back home, I called Northern Snow Services directly. A tired-sounding man answered on the third ring. Northern Snow, this is Carl. Hi Carl, my name is Harrison Drake. I live in Riverside Meadows, and I believe one of your plows damaged my fence during the last storm. I would like to file a damage claim. There was a pause. You will need to talk to Gary, our owner. He handles all the damage claims. But I have got to tell you, we have had about 20 calls like this already this season. Worst winter we have seen in years. That was interesting. 20 calls meant I was not alone in this problem. Is Gary available? He is out on a site right now, but I can have him call you back. What is your address? I gave him my information and hung up feeling slightly more optimistic. If Northern Snow had multiple damage claims, they had to have records of where their plows went and what might have happened. Gary called back 2 hours later. He sounded stressed and exhausted. Mr. Drake, look, I am sorry about your fence. This winter has been brutal for everyone. But my contract is with the HOA, not individual homeowners. Any damage claims have to go through them. The HOA is refusing to take responsibility, I said. They are fining me for damage your plow caused. Gary sighed heavily. Yeah, I have heard that from other folks in your community. Between you and me, the HOA president is a real piece of work. She has been on my case all winter about not piling snow high enough at the edges, but when I do what she asks, properties get damaged. I am stuck between a rock and a hard place here. You have records of where your plows went and when. Time-stamped GPS data, anything like that. We do, actually. All our trucks have GPS tracking for liability purposes. But again, I cannot just hand that over to you. The HOA would have my head. I thought for a moment. What if I subpoenaed those records? If I took the HOA to small claims court over this fine, I could legally request your GPS data as evidence. There was a long pause. If you went that route, I would have to comply with a court order. And honestly, it might help me out too. I am tired of getting blamed for everything. The HOA wants the streets perfectly clear, but they do not want to accept the consequences of aggressive plowing in tight spaces. We talked for a few more minutes, and I hung up with a plan forming in my mind. If Brenda wanted to play hardball, I could play too. The next step was researching HOA law in Minnesota. I spent the entire evening going through state statutes and case law. Minnesota had fairly strong homeowner protections, but HOAs also had broad powers granted by their covenants. The key issue was proving the damage was not my responsibility. If I could show the HOA's contractor caused the damage, Then the HOA had a legal obligation to either cover the repairs or file a claim against their contractor's insurance. I drafted a formal letter to the HOA citing the specific statutes and requesting they suspend the fine pending an investigation. I included my photos and a detailed explanation of why the damage was clearly impact-related. I also formally requested copies of all snow removal records for my street during the relevant time period. I sent the letter via certified mail so they could not claim they never received it. 3 days later, I got a response. Brenda had apparently decided to escalate things. The letter informed me that not only was the fine still in effect, but I was now being fined an additional $500 for harassment of HOA board members and staff and frivolous complaints. The letter also stated that all my communications must now go through the HOA's attorney, a firm called Mitchell and Associates. I had to laugh at the absurdity of it. They were trying to intimidate me into backing down, but all they had done was confirm they were hiding something. If the Plow records showed no damage, they would have just shown them to me. The fact that they were stonewalling meant there was evidence they did not want me to see. I called Mitchell and Associates and asked to speak with whoever was handling the Riverside Meadows account. I was transferred to a lawyer named Jennifer Mitchell. "Mr. Drake," she said in a crisp, professional tone, "I have reviewed your file. The HOA's position is clear. You are responsible for maintaining your property, and the damage to your fence is your responsibility regardless of cause. The covenant you signed makes this explicit. Then you would not mind if I file a small claims suit against the HOA and subpoena the snow removal records," I said calmly. "Because if those records show the Plow hit my fence, the HOA is liable for the damage and for the wrongful fines they have levied against me." There was a brief pause. "Mr. Drake, litigation is expensive and time-consuming. Even if you were to win, which is far from certain, you would spend more in legal fees than the cost of simply repairing the fence. I strongly suggest you reconsider this course of action. I am representing myself, so legal fees are not an issue, and this is not about the money anymore. This is about the principle. The HOA is wrong and I am going to prove it." "Very well," she said coolly. "We will see you in court." I spent the next week preparing my small claims case. In Minnesota, small claims court could handle disputes up to $15,000, and you did not need a lawyer. I filed my complaint seeking the cost of fence repairs, estimated at $3,000, plus the wrongful fines totaling $2,500, and compensation for my time and effort in dealing with this mess. The court date was set for 6 weeks out. In the meantime, I received another letter from the HOA informing me that since I had not begun repairs, I was now being fined $100 per day, just as they had threatened. The letter had a smug tone to it, as if they were certain I would crack under the financial pressure. Instead, I documented every single fine and added them to my court claim. I also reached out to other homeowners in the community who had mentioned fence damage. Carl from Northern Snow had said there were about 20 calls. If I could find even a few of those homeowners, it would strengthen my case. I printed flyers and walked around the neighborhood one Saturday afternoon, looking for damaged fences. I found 7 properties with obvious Plow damage, all in similar locations where the plows turned around or pushed snow to the sides. I left flyers with my phone number and a brief explanation of my situation. By the end of the weekend, 4 homeowners had called me. They all had similar stories. The HOA had either fined them or threatened fines for fence damage that clearly came from the plows. Most had just paid for repairs rather than fight, not wanting the hassle of dealing with Brenda and her board. One homeowner, a retired teacher named Margaret Chen, was particularly angry about the situation. "They fined me $1,500, she said. "I am on a fixed income. I could not afford to fight them, so I paid a contractor to fix the fence and paid their fine. It wiped out most of my savings. But if you are taking them to court, I want to testify. This is wrong and someone needs to stand up to them." I now had witnesses and documentation of a pattern of behavior. The HOA was systematically fining homeowners for damage their own contractor caused, essentially double billing for the problems created by aggressive snow removal. As the court date approached, I submitted my evidence list and witness list to the court and served copies to the HOA's attorney. The list included my photos, expert testimony from a fence contractor about the nature of the damage, testimony from Margaret and 2 other homeowners, and a subpoena for Northern Snow's GPS records for my street during the relevant storm. 2 weeks before the court date, Jennifer Mitchell called me. Her tone was slightly less icy than before. "Mr. Drake, my clients are willing to offer a settlement. They will waive all fines and split the cost of fence repairs with you 50-50. This is a generous offer considering the covenant clearly places maintenance responsibility on homeowners." "No," I said simply. "The damage was caused by the HOA's contractor following the HOA's instructions to aggressively clear snow. The HOA is 100% liable, not 50%. I will see you in court." "You are making a mistake," she said. "The judge is not going to look favorably on a homeowner who refuses a reasonable settlement." "We will let the judge decide what is reasonable," I replied and hung up. The night before the court date, I could barely sleep. I had my evidence organized in a 3-ring binder with tabs for each section. I had practiced my statement multiple times. I had confirmations from my witnesses that they would be there. Northern Snow had confirmed they received the subpoena and would provide the GPS records. Everything was as ready as it could be. The Hennepin County Courthouse was busy when I arrived at 8 in the morning. Small claims court started at 9, and there were about 15 cases on the docket. Mine was 3rd on the list. Brenda Patterson arrived with Jennifer Mitchell, both women dressed in expensive business suits. They looked confident, like this was a minor inconvenience rather than a real challenge. Margaret Chen arrived with her husband, and the other 2 homeowners I had asked to testify showed up as well. Gary from Northern Snow arrived looking uncomfortable, carrying a laptop and a folder of documents. When my case was called, we all moved to the front. The judge was a woman in her 60s with sharp eyes and a no-nonsense expression. Her nameplate read, "Judge Sarah Martinez." "This is Drake versus Riverside Meadows Homeowners Association," she said, reviewing the file. "Mr. Drake, you are representing yourself, correct?" "Yes, Your Honor." "And Miss Mitchell, you are representing the HOA?" "Yes, Your Honor." "Mr. Drake, this is your complaint. Please state your case." I stood and took a breath. "Your Honor, 8 months ago I purchased a home in Riverside Meadows. This winter, during a major snowstorm, the HOA's contracted snow removal service damaged my fence. Instead of taking responsibility, the HOA fined me $2,000 for the damage and an additional $500 for requesting the records that would prove my case. They have also been fining me $100 per day since I refused to pay. I am asking the court to rule that the HOA is responsible for the damage, to order them to pay for repairs, and to void all wrongful fines." Judge Martinez looked at Jennifer Mitchell. "What is the HOA's position?" Mitchell stood smoothly. "Your Honor, the HOA covenant clearly states that homeowners are responsible for maintaining their property, including fences. Mr. Drake signed this covenant when he purchased his home. Winter damage is common in Minnesota, and all homeowners accept this responsibility. The HOA has no liability for general winter wear and tear. Your Honor, I interjected, this was not wear and tear. This was direct impact damage from a snow plow. I have photographic evidence, expert testimony, and GPS records proving exactly when and how the damage occurred. Judge Martinez gestured to me. Show me your evidence, Mr. Drake. I opened my binder and walked her through the photos. I pointed out the plow marks in my yard, the direction of the broken boards, the ice chunks wedged in the fence. Your Honor, I am a general contractor with 15 years of experience. This type of damage only occurs from direct impact with heavy machinery. The boards are pushed inward with splintering consistent with a heavy blade striking them at speed. I then called my first witness, a fence contractor named Robert Hughes, who had examined the damage at my request. He testified that, in his professional opinion, the damage was definitely caused by impact with a plow or similar equipment, not by wind or ice loading. Next, I called Margaret Chen. She explained how her fence had been damaged in a similar way and how the HOA had fined her despite obvious plow damage. The other two homeowners gave similar testimony. Then it was Gary's turn. He looked nervous as he took the stand. Mr. Thompson, you are the owner of Northern Snow Services, correct? I asked. Yes, I am. And your company has a contract with Riverside Meadows HOA to provide snow removal services? Yes, we do. Can you describe the nature of that contract and any specific instructions you received from the HOA? Gary shifted uncomfortably and glanced at Brenda. The contract specifies that we keep all streets and main walkways clear of snow within 12 hours of a storm ending. This past winter, the HOA president, Mrs. Patterson, contacted me several times asking us to be more aggressive with snow removal, specifically requesting that we push snow as far to the edges of properties as possible to keep streets completely clear. And did you comply with those requests? Yes, we did. But I warned Mrs. Patterson that pushing snow that aggressively in tight spaces could cause property damage. She said the HOA would handle any issues that came up. That caused a stir in the courtroom. Brenda's face went red and Jennifer Mitchell was furiously taking notes. Your Honor, I said, I would like to submit the GPS records from Northern Snow's plows as evidence. Gary opened his laptop and pulled up a mapping program. He showed the judge the GPS track from the plow that serviced my street during the storm in question. The plow had come down my cul-de-sac at 2:47 a.m. on February 18th. The GPS showed it had stopped at the end of the cul-de-sac, reversed, and then turned around in a tight circle that brought it within inches of my property line. This is the exact location of Mr. Drake's fence, Gary said, pointing to the screen. And you can see from the speed and path data that the plow was moving at about 15 miles per hour when it made this turn. At that speed, in those conditions, if the blade caught the edge of a fence, it would definitely cause the kind of damage we saw. Judge Martinez studied the screen carefully. Do you have any other records from that night? Any notes from the driver? Gary nodded and pulled out a paper from his folder. The driver noted in his log that he felt the plow catch on something during that turn, but when he checked, he did not see any obvious damage because of the darkness and heavy snow. He reported it to me the next morning, but by then, the snow had covered everything. Why was this not reported to the HOA or Mr. Drake at the time? The judge asked. I tried to call Mrs. Patterson that morning, Gary said. I left a voicemail explaining that we might have clipped a fence on Cedar Court during the night shift. She never returned my call. I assumed she was handling it. All eyes turned to Brenda. She looked like she wanted to disappear into her chair. Judge Martinez looked at Jennifer Mitchell. "Miss Mitchell, do you have any evidence to counter what we have heard?" Mitchell stood, but her confidence had evaporated. "Your Honor, even if the plow caused some of the damage, Mr. Drake's covenant still requires him to maintain his property. The HOA cannot be held responsible for every incident that occurs during routine maintenance." "Miss Mitchell," the judge said with an edge to her voice, "we are not talking about routine wear and tear. We are talking about direct property damage caused by the HOA's contractor following the HOA president's explicit instructions to plow aggressively. The contractor reported the incident, and the HOA president ignored it. Then, instead of accepting responsibility, the HOA fined the homeowner for the damage they caused. Do I have this right?" Mitchell had no good response. "Your Honor, I would need to consult with my client about these new revelations." "I am sure you would," Judge Martinez said dryly. She looked at me. "Mr. Drake, how much will it cost to repair your fence?" $3,000, Your Honor. I have 3 quotes from licensed contractors." She made some notes. "And what is the total amount of fines you have been assessed?" I did a quick calculation. "As of today, $4,300, Your Honor." Judge Martinez shook her head. "This is exactly the kind of HOA overreach that gives these organizations a bad reputation. Mr. Drake, I am ruling in your favor on all counts. The HOA will pay for your fence repairs in the amount of $3,000. All fines are void and must be removed from your account immediately. And I am ordering the HOA to pay you an additional $2,000 in punitive damages for wrongful fining and failure to act in good faith." She turned to Jennifer Mitchell and Brenda. "Furthermore, I am ordering the Riverside Meadows HOA to review all fines assessed for winter damage this season, and to refund or void any fine where the damage could reasonably have been caused by your snow removal contractor. You have 60 days to complete this review and submit a report to this court. You understand?" Brenda looked like she had been slapped. Mitchell simply nodded. "Yes, Your Honor. Good. This case is closed. Next case." I walked out of the courtroom feeling like I had just won the lottery. Margaret Chen hugged me, tears in her eyes. "Thank you," she said. "Thank you so much. Maybe now I will get my money back." Gary shook my hand. "I appreciate you not throwing me under the bus in there. And for the record, I am not renewing our contract with Riverside Meadows next season. I am done dealing with that woman." Over the next few weeks, the fallout from the court case rippled through the community. The HOA was required to send letters to all homeowners who had been fined for winter damage, offering full refunds. Margaret got her $1,500 back, plus the cost of her fence repairs. In total, the HOA had to refund over $30,000 to various homeowners. Brenda Patterson resigned as HOA president 2 weeks after the court case. I heard through the neighborhood grapevine that the other board members had forced her out, terrified of further legal liability. The new president, a mild-mannered accountant named Tom Foster, immediately instituted new policies requiring the HOA to investigate all damage claims before issuing fines and to maintain transparent records of contractor activities. Northern Snow did not renew their contract, as Gary had promised, and the new snow removal company the HOA hired was instructed to prioritize careful operations over aggressive clearing. My fence was repaired by mid-May, paid for entirely by the HOA. I made sure to use the most expensive contractor of the 3 I had gotten quotes from, and I upgraded to premium cedar boards instead of the basic pine that had been there before. The HOA check cleared without issue. The $2,000 in punitive damages went toward a nice vacation to Colorado that summer. I had not traveled since my wife died, and it felt good to get away and breathe mountain air. But the best part of the whole experience was not the money or the fence. It was the principle of the thing. I had stood up to bullies who thought they could push around a new homeowner who did not know any better. I had proven that even powerful organizations like HOAs had to follow the law and act in good faith. And I had helped other homeowners get justice too. The following winter was much milder, and we only got about 30 inches of snow total. The new snow removal company was careful and professional, and I did not see any damaged fences in the neighborhood. Tom Foster ran the HOA in a completely different way than Brenda, actually listening to homeowners and treating us like valued members of a community rather than subjects to be controlled. I ran into Jennifer Mitchell at a coffee shop about 6 months after the court case. She was in line ahead of me, and when she turned around with her latte, she recognized me immediately. "Mr. Drake," she said, not quite smiling but not hostile either. "How are you?" "Doing well," I said. "How are things at your firm?" she sighed. "We dropped Riverside Meadows as a client after your case. Too much liability, and frankly, Mrs. Patterson was impossible to work with. She would not listen to legal advice and then blame us when things went wrong." "I imagine that made your job difficult," I said. "You have no idea," she said. "For what it is worth, you were right. The HOA should have taken responsibility from the start. It would have saved everyone a lot of time and money." "Well, I appreciate you saying that," I said. She nodded and left, and I never saw her again. Life in Riverside Meadows settled into a comfortable rhythm. I made friends with several neighbors, including Margaret and her husband. We started a neighborhood watch program and a community garden. The HOA meetings became productive sessions where actual issues were discussed and resolved rather than platforms for one person's power trips. About a year after the fence incident, I was elected to the HOA board myself. I had not planned on it, but several neighbors approached me and said they wanted someone on the board who would stand up for homeowners' rights. I reluctantly agreed and found myself working alongside Tom Foster and 3 other reasonable people who actually cared about making the community better. One of my first initiatives as a board member was to create a formal dispute resolution process. Before any fine could be issued, there had to be a documented warning, photographic evidence, and an opportunity for the homeowner to respond. If the homeowner disputed the fine, there would be a hearing before the full board, not just a decision by the president alone. It was common sense stuff that should have been in place from the beginning. We also revised the snow removal contract to explicitly state that the contractor was liable for any property damage caused by their equipment, and the HOA would support homeowners in damage claims against the contractor. It was a small change that protected everyone and ensured we would never have a repeat of the previous winter's disaster. Brenda Patterson moved out of the community about 18 months after the court case. I heard she had joined the HOA board of a different neighborhood, but I hoped she had learned something from the experience. Probably not, though. People like that rarely do. As for me, I finally felt at home in Riverside Meadows. My house was no longer just a place to escape memories. It was a real home in a real community. I had fought for justice and won, and that victory had opened doors to real connections with my neighbors. I had thought I was done building things after retiring from contracting, but I realized I was building something even more important now, a community based on fairness, respect, and common sense. The fence, now rebuilt with beautiful cedar boards, stood as a reminder that sometimes you have to stand your ground and fight for what is right. Every time I looked at it, I remembered Brenda's smug face in that first meeting when she dismissed my concerns. I remembered the stress of preparing for court, the satisfaction of watching Gary present that GPS data, and the look on Judge Martinez's face when she realized just how badly the HOA had behaved. I also kept the original orange envelope that started it all. It was pinned to a corkboard in my home office, right next to the court judgment in my favor. Not because I wanted to hold on to anger or resentment, but because it was a reminder that bullies come in all forms, even in suburban homeowners associations, and that standing up to them is always worth the effort. On winter evenings, I would sometimes sit by my back window with a cup of coffee, watching snow fall gently on my yard and my fence. The new snow removal company would come through in the morning, carefully clearing the streets without destroying property. The neighborhood would wake up to clean roads and intact fences, the way it should be. Margaret would occasionally call me when she had a question about HOA policies, or when she heard about another homeowner having a dispute. I always made time to help. She had stood by me in court when she did not have to, and I would never forget that. We had formed a bond through that experience, proof that even bad situations can create good friendships. Tom Foster turned out to be an excellent HOA president. He was organized, fair, and actually interested in serving the community rather than controlling it. Under his leadership, the HOA budget was transparent, meetings were productive, and fines were rare and always justified. It was amazing what a difference leadership made. Sometimes I wondered what would have happened if I had just paid the initial fine and fixed the fence myself. I would have been out thousands of dollars, but I would have avoided the stress and time of fighting the HOA. But then I would remember Margaret's tears when she talked about her depleted savings and the other homeowners who had been wrongfully fined, and I knew I had made the right choice. Some fights are worth fighting, not just for yourself but for everyone else who comes after you. The story spread beyond our community. I got calls from homeowners in other HOAs who were dealing with similar issues, asking for advice. I always told them the same thing: document everything, know your rights, and do not be afraid to stand up for yourself. HOAs have power, but they are not above the law, and courts do not look kindly on abuse of that power. A local news station even did a story about the case, using it as an example of HOA overreach. The reporter interviewed me, Margaret, and Tom Foster about what had happened and how the community had changed. Brenda was invited to participate but declined. The segment aired during sweeps week and apparently got good ratings. For a few days, I was a minor local celebrity, which was amusing but also a bit uncomfortable. I had not done this for fame. I had done it because it was right. But the attention did lead to something positive. A state legislator saw the news story and reached out to me about potential HOA reform legislation. We met for coffee, and I explained the issues I had seen: lack of transparency, no real oversight, and too much power concentrated in the hands of people who sometimes abused it. He was interested and said he would look into it. I did not expect much to come from that conversation, but the following legislative session, a bill was introduced to strengthen homeowner protections in HOA disputes. It required HOAs to provide clear documentation of violations before issuing fines, established a state-level appeals process, and imposed penalties on HOAs that engaged in wrongful fining practices. The bill passed and was signed into law. I attended the signing ceremony at the state capitol in St. Paul. The legislator who sponsored the bill acknowledged me in his remarks, saying my case had been the inspiration for the legislation. It was surreal standing there in the Capitol building, realizing that my fight over a fence had led to protections for homeowners across the entire state. But mostly, life just went on. I worked on my house, maintained my yard to reasonable standards, and enjoyed being part of a functional community. I dated occasionally, though nothing serious developed. My daughter, who lived in Chicago, visited more often, pleased to see me engaged with life again instead of just going through the motions. She had been worried about me after her mother died, concerned that I was isolating myself. But now she could see I had built a new life. I had friends, purpose, and a home I truly cared about. The HOA battle, as frustrating as it had actually helped pull me out of my grief by giving me something to fight for. Years passed, and the fence incident became part of community lore. New homeowners would hear about it and laugh, shaking their heads at the absurdity of the original fine. The story always ended the same way. But we have got a good HOA now, nothing to worry about. I eventually stepped down from the HOA board after serving 2 terms. I had done what I set out to do, helping establish fair policies and a culture of transparency. It was time to let others lead. But I stayed involved, attending meetings and speaking up when I thought it was necessary. The fence itself aged gracefully. The cedar boards weathered to a beautiful silver gray, and I never had to worry about major damage again. Every few years I would apply a fresh coat of sealant, but that was it. It stood strong and solid, a literal and metaphorical boundary between my property and the world beyond. On the 10th anniversary of the court case, Margaret threw a small party at her house. She invited everyone who had been involved. Me, the other homeowners who had testified, Tom Foster, and even Robert Hughes, the fence contractor who had provided expert testimony. Gary from Northern Snow had moved to Arizona, but he sent a card saying he remembered the case fondly, as the moment he decided to stop working with difficult clients. We sat in Margaret's backyard on a perfect June evening, eating grilled burgers and sharing stories. We laughed about Brenda's face when the GPS records were shown in court. We marveled at how much the community had changed. We toasted to standing up for what is right, even when it is difficult. "You know," Margaret said at one point, "that case changed my life. I was so used to just accepting things, not making waves. But watching you fight back taught me that sometimes you have to make waves. I have been so much more confident since then, in all areas of my life." Others nodded in agreement. The case had been a turning point for all of us, a moment when we realized we had more power than we thought. We were not helpless against arbitrary authority. We had rights, and those rights meant something if we were willing to defend them. As the party wound down and guests started leaving, I walked home under a sky full of stars. The streetlights of Riverside Meadows cast a warm glow, and I could hear laughter from other backyards, the sounds of a community at peace. I thought about everything that had happened since that orange envelope appeared in my mailbox all those years ago. I had moved to this neighborhood to escape the past and start fresh. I had gotten more than I bargained for, a battle I had not wanted but needed to fight. And through that battle, I had found something I did not know I was missing, a sense of purpose and belonging. I had made a difference, not just for myself but for my neighbors and eventually for homeowners across the state. The fence stood in my backyard, still solid, still intact. It was more than just a property line now. It was a symbol of resilience, of standing firm against those who would push you around. Every board represented a choice to fight back, to demand fairness, to refuse to be a victim of bureaucratic bullying. I went inside and looked at that orange envelope still pinned to my corkboard. It seemed like a relic from another lifetime now, though it had only been 10 years. So much had changed. I had changed. The community had changed. Even the law had changed. But one thing remained constant: the importance of standing up for what is right, no matter how powerful the opposition or how difficult the fight. That lesson was worth more than any fence, any amount of money, or any legal victory. It was a lesson I would carry for the rest of my life, and one I hoped to pass on to anyone who needed to hear it. I made one final cup of coffee and sat by my window, looking out at my fence in the moonlight. Somewhere across town, there was probably another homeowner getting an unfair fine from an overzealous HOA. But now, they had legal protections that did not exist before. They had a framework for fighting back. And if they needed inspiration, they might hear the story of the man who fought back against his HOA over winter fence damage and won. That story would outlive me, I realized. It had already taken on a life of its own, spreading through neighborhoods and inspiring legislation. It was no longer just my story. It belonged to everyone who had ever felt powerless against an unjust system. And that was the best possible outcome. I finished my coffee and went to bed, content with the life I had built and the small but meaningful difference I had made in the world. Tomorrow would bring new challenges, new opportunities, and new chances to stand up for what is right. But tonight, I could rest knowing that I had fought a good fight and won, not just for myself but for everyone who came after. The fence stood guard in the darkness, strong and proud, a testament to perseverance and justice. And in the morning, when sunlight touched those cedar boards, they would glow with warmth, reminding me once again that even the smallest battles can have the biggest impacts.